Good day, Crime Talk aficionados. It's a new video and it's Saturday. So what does that mean? It's the weekly recap of all of the top stories that you missed throughout the week. Hope you enjoy the recap. We'll see you next time on Crime Talk. All right, let's get straight to the docket. Now, we have talked about the Murdock case down in South Carolina. Paul and Maggie Murdock were shot in early June, and obviously they passed away as a result of their injuries. And the family has had a lot of controversy. And although there were always talk that the Murdock family received special privilege because young Paul Murdock's father, his grandfather, and his great-grandfather were all involved in the judicial system down there for the last 85 years, it's basically been called a situation where nothing got done in the criminal justice system unless the Murdocks approved it. I did not realize this, but I was reading some commentary and a lot of comments in regards to the commentary section of a newspaper down in South Carolina. And the thing that jumped out at me, and it was rather interesting, and it makes you think, you realize how jaded people become with the judicial system when you see a comment like this. But yet, I think I understand why. Think about how many times we see public figures, we see politicians who clearly have violated the law, and if it was you or me, we would be charged immediately. But because who they are and maybe the status that they hold, nothing ever happens, right? We've all seen it where the investigation is ongoing and it goes on for years and nothing happens. And in this particular case, the comment that jumped out at me was said that, if no one is ever charged with the death of Paul and Maggie Murdock, then a Murdock was involved. Now, we are certainly not saying that anyone in the Murdock family had anything to do with the death of Paul and Maggie, but I thought that was a very interesting comment. And given the power that this family exercised over the judicial system down there as the prosecutors for so long, it really makes you have to wonder, is this the system we want, where individuals have no faith and they know that depending on somebody's last name, that someone may never be charged? We basically saw the interference that the family ran when Paul Murdock was charged or was under investigation for the boating accident, which resulted in the death of Mallory Beach. Family was trying to interview witnesses before the police could, try to get people lawyers, trying to get their stories straight. So I thought that was rather interesting. If you know that nobody's going to be charged, a Murdock must be involved. And we know that Paul Murdock was charged in the death of Mallory Beach in the boating accident, but it was only something that, for lack of a better term, got into the public and they had to file charges. And once it got out of the kind of local police, charges had to be filed. But I think it had more to do with the public, indeed. So just something to think about, but I think that shows a lot of the cynicism that people have with the judicial process. Let me know your comments below. Do you have faith in the justice system? Do you think it works? Do you think there's two tiers of justice? One for the powerful and wealthy, and then one for everyone else? Let me know. Governor Andrew Cuomo, he was under investigation by the New York Attorney General based upon allegations that he is kind of a weird, creepy guy, that he would sexually harass women in his office. But in typical Governor Cuomo fashion, he denied it. Everybody's lying. And if you don't believe me, you obviously just hate me and you're a mean person. So the investigation goes forward. The Attorney General delivers her report. And what does she say? She concludes that Governor Cuomo has harassed at least 11 women and then retaliated against a former employee who complained publicly about his conduct. Now, the Attorney General, Letitia James, not exactly known for not being a partisan, but in this particular case, she had to go where the facts led her. And apparently in her 165-page report, which they conducted 179 interviews and reviewed tens of thousands of documents, and they basically said that Cuomo's office was riddled with fear and intimidation and a hostile work environment. It's also alleged in the report, and these reports have been made public now. There's at least two more allegations that have been made public, and we'll see if criminal charges are going to be filed against Governor Cuomo. There was already talk of let's impeach Cuomo, but in Cuomo fashion, what did he do? He threatened everybody who wanted to impeach him, and basically does what Cuomo does, threaten people. And he has to stay in office. So now is going to be the big question. The citizens of New York, are they going to allow a creeper like Cuomo to stay in office? Well, I don't know. I mean, there's been lots of people that have resigned positions because of allegations that were never really investigated. And these allegations, and basically the report said that the governor's denials lack credibility and were inconsistent with the weight of the evidence gathered throughout the probe. So when the lead prosecutor in the state, who's of the same political party as you are, calls you a liar and a creepy dude, oh, you may want to think about it. But he won't. Why? Because what job could Governor Cuomo do outside of politics? I can't think of any. Can't think of any. The real question is now, what are the citizens of the state of New York going to do? What will the legislature do? And what will the police departments do as far as filing criminal charges? If you or I engaged in the conduct outlined in this report, which you all can read, it's made public, you would be charged with crimes of unlawful sexual contact. And what's worse is the retaliation of people that came forward who followed the law that said, Governor, these are your own procedures. You've made me feel uncomfortable. You're touching my belly button. Yeah. And he retaliates against these people that make allegations. We'll see if criminal charges should be filed. If this were you or me or all your family, your friends, your coworkers, not only would you be fired, you would more than likely be charged criminally as well. Let's see what happens. Or is it going to be a typical politician? Is he going to resign to spend a little more time with his family? I doubt Cuomo would ever admit that he did anything wrong. And maybe somebody will have enough chutzpah to charge the good governor. Somehow, I think it will just kind of fade away in the news cycle and everything will go on. Let me know what you think. Should the good governor resign? R. Kelly. Boy, this guy has wished he could fly away. That's for sure. But he is not going anywhere. Anyway, he starts a trial next week, Mr. Kelly, in New York. And this is in regards to the racketeering, bribery, coercion, and enticement and sex trafficking charges that he is facing. Now, Mr. Kelly's been in custody for the last 2 years. And so they had a pretrial readiness conference. And this is not unusual. Right before you get to trial, everybody knows, all right, we're going to trial. Judge makes some final orders. They go through the jury selection process again, if there's any unique rules to the courtroom, any last minute issues. Here, one of the last minute issues is apparently Mr. Kelly has been gaining a few pounds over the last couple of years and needs to be remeasured so that he can, have his suits fit comfortably at trial. Now, usually when your client is in custody, unless they provide the clothes from the family, that's right, the defense attorney has to do it. It depends what you get for your client. Sometimes you send your staff off to a quick trip to Target and get some Dockers and a couple of shirts to get through the trial. It's always a little sad oftentimes when nobody has anybody that can be called to bring them clothes for trial. Kind of sad when you're the only one there sitting with your client. Mr. Kelly also requested that he be granted a free transcript of the proceedings at no cost to him because he's now indigent, and these attorneys are being paid as a CJA counsel. So why is that significant? Well, most people don't realize this, but transcripts are expensive. Why? Well, those court reporters, they are very good at what they do, particularly the ones up in the U.S. District Court system. They have a lot of experience, and they're good. So for them to do it real time, and I'm not saying they're always perfect, but they're pretty close to perfect, they charge for their service, right? Because normally when you get a transcript, it's not available usually for weeks or months because the court reporter has to review it, correct any additions. Sometimes they go back and listen to an audio recording of it to make sure they got it correctly. It takes a lot of time. So every time a transcript is made, that court reporter has probably proofed and heard that trial 3 to 4 times by the time you get a final version of the transcript. You can pay for the real-time transcription, either A, by the court reporter, which comes as a fee, and you'll get it as it goes across the screen. There may be a couple of errors in it, but most of those court reporters are really good. Or sometimes in a civil matter, the attorneys pay for the court reporter themselves if they want it and they don't want it recorded on an electronic recording device. But once again, that is very expensive. So since Mr. R. Kelly has been indisposed the last couple of years, he has not been able to work and his resources have been depleted. But let's talk about the big issue. The court made some rulings, and this is a good opportunity to talk about the rape shield statutes. Now, just about every state has a rape shield, as well as the federal rules also have a rape shield statute. Now, what does that mean? Okay, so it used to be that when somebody was an accuser of somebody, whether male or female, and it came down to going to trial, the defense attorney would be allowed to get into all of the past sexual relationships that the victim had, either before that night or after that night. Well, that has been changed, and in a lot of states, even in civil cases, that is no longer permissible as it comes in. So in this particular case, the judge has ruled that there will not be any testimony elicited from either the prosecution or the defense, in particular to a witness's mental health treatment that she was engaging in. We also have been told that one of the witnesses later worked as an exotic dancer after allegedly being accused by Mr. R. Kelly, and that is not coming in as well. So what's the purpose of rape shield? Well, it's there to define the night in question. Now, like all things in the law, there are exceptions to the rule. Now, the rape shield statute says you cannot bring in all these other instances of sexual activity with other individuals other than the victim. That's right. So if there had been an ongoing relationship with the complaining witness and the defendant, you can bring that in to show consent. You can also bring it in to show that maybe somebody else did it. So, for example, there's an allegation made, there's a sexual assault kit done, and it comes back that there's, say, maybe semen from somebody other than the defendant. You can use that to show that it was somebody else. Okay? So there's very narrow circumstances where you can get into other areas as it relates to sexual misconduct. However, if the witness opens up the door or the prosecution opens up the door and they basically bring their kind of good character into it and say, well, I would never have done this because I have lived a pure life and I would never have engaged in such conduct, that's when the defense can then pounce with all of this type of information. This statute for the defense can be oftentimes frustrating indeed, but you have to do it. It applies not only to the victims, it also applies to witnesses. And I can remember when I was a young lad, I thought the judge was going to leap over the bench and object on his own, because there was conversations about a situation where there was this big party and everyone went back and people were engaging in complete debauchery, what have you. And I was questioning the witness about it, and judge told me to get up there, and he's like, "Mr. Reich, I thought that the rape shield statute applies to witnesses as well. We had to have a hearing on this." And I'm like, "Oh, sorry, Your Honor, but I got it all in." And ultimately, that was a case where the DA dismissed after we came back from lunch, after the cross-examination of the witness. So sometimes it's actually relevant to set the scene. Sometimes you have to take those chances, and when the DAs don't object, you move forward. So we'll see how that works out for R. Kelly. I think R. Kelly is going to have a difficult trial. Maybe he will win not guilties on a couple of counts, but I think that Mr. R. Kelly needs to enjoy probably one of the last times that he'll ever wear civilian attire outside of a courtroom setting, indeed. Breaking news in the Lori Vallow, Chad Daybell matter. Well, some breaking news for Chad for sure. The prosecutors have filed their notice of intent to seek the death penalty. That's right. I personally didn't think that this was a death penalty case, but maybe I'm just a little too skewed by living in kind of a big city where, 3 dead bodies just really doesn't get you much anymore. But in Idaho, it gets you the death penalty. Anyway, the district attorney has filed basically the reasons why they're seeking the death penalty are: first, the murder of Tylee Ryan was committed for remuneration. That's right, money. Same thing as it relates to J.J. Vallow. The murder of Tammy Daybell was committed for remuneration, money. That's right. The next reason, the murder of Tylee Ryan was especially heinous, atrocious, or cruel, manifesting exceptional depravity. The murder of J.J. Vallow was especially heinous, atrocious, or cruel, manifest exceptional depravity. The murder of Tammy Daybell was especially heinous, atrocious, or cruel, manifesting exceptional depravity, and or by the murders or circumstances surrounding their commission, the defendants exhibited utter disregard for human life, and the defendant by his conduct, whether such conduct was before, during, or after the commission of the murders at hand, has exhibited a propensity to commit murder, which will probably constitute a continuing threat to society. Wow. Those are the reasons under the statute in Idaho that the prosecutor could select from as to why they're going forward. What does this mean? Well, I don't think we're going to get this trial in by the end of the year, given the new nature of the case. Ultimately, the death penalty is the ultimate punishment, although rarely actually implemented, at least anytime very soon. But the defense will require a significant amount of time to prepare and present a case in mitigation if ultimately there is a conviction in the case. The next thing that comes up is the fact that counsel for Mr. Daybell may not have any death penalty experience. Certainly the defendant, the court, may want an attorney that has death penalty experience under their belt, so to speak. Now, this only applies to Chad Daybell because, that's right, Lori Vallow is still not competent to proceed and her case is pending. But one would have to assume that if Lori Vallow was restored to competency, that she may have the same notice of intent filed in her case. All right, we brought it to you yesterday afternoon. The state of Idaho has decided to seek the ultimate punishment against Chad Daybell. The prosecution filed a notice of intent to seek the death penalty in regards to the allegations related to the death of Tylee Ryan, J.J. Vallow, and Tammy Daybell. The district attorney cited the statutory requirements for the death penalty in Idaho, specifically saying that the crimes were especially heinous, atrocious, or cruel, manifesting exceptional depravity. that there was a complete disregard for human life, and the fact that the crimes involved remuneration, that they were done for money, right? The insurance money, the Social Security money, all that goes into play. Now, obviously, Lori Vallow has not been charged. Well, she hasn't been given an opportunity to enter a plea of not guilty, so that has not triggered anything in regards to seeking the death penalty as it relates to Lori Vallow. One would think if they're going to go after Chad Daybell, they would do the same for her if and when she is restored to competency. Now, a lot of people in the comments said, Scott, I was surprised that you were surprised. Well, let me tell you why. When there's allegations of mental health concerns, it usually is a huge mitigating factor when it comes to the death penalty. What comes to mind, for example, is the James Holmes shooting that took place here in Colorado, where there were, I believe, 12 deceased. And guess what? The jury did not convict as it related to the death penalty. They did not impose it. They convicted him, found him guilty of all the heinous things he did, but they didn't impose the ultimate punishment. I personally have had cases where they didn't go death on a case that I was representing, where we had 3 victims and a horrific sexual assault before the deaths all took place. So somebody was quite offended in the comments that said, I can't believe, Scott, that you wouldn't be offended by this, and are you that callous? No, I'm just being realistic as possible. When you have a defendant that really has had no criminal history, it's kind of tough to pitch to a jury that they deserve the ultimate punishment. Yes, I understand there's children involved. Yes, I understand this weirdness that's going on. But if there's mental health issues, it's going to be somewhat difficult. We will see. Now, the other issue that I wanted to talk about as it relates to this matter is, I mentioned yesterday, I would expect a further delay. Now, one of the things that we've talked about this before just briefly is when you go death, there are certain standards, and the ABA and their guidelines, but in the state of Idaho, they have adopted the ABA guidelines as it relates to the performance standards of capital counsel qualifications. All right. The ABA recommends, and like I said, the state of Idaho has recommended these guidelines, particularly as it relates to their public defender's office, but I think it carries true, right? These are standards that people are saying should be met. Guess what? If there's a conviction and these standards aren't met, raises really good issues for post-conviction relief. So the big one, the defense team. 1, the defense shall consist of no fewer than 2 attorneys qualified in accordance with these standards. The defense shall contain at least 1 member qualified by training and experience to screen individuals for the presence of mental or psychological disorders or impairment. In a case in which the death penalty may be imposed, at the first court appearance after a crime in which the death notice would be filed is charged, 2 qualified defendant attorneys should be appointed to represent an indigent defendant. Now, the question becomes, Chad Daybell is in custody. He's technically indigent. He would easily qualify for the public defender. John Pryor, his attorney, needs to take a look at his qualifications and remove himself from the ego, the high-profile nature of this case, and say, hey, am I really qualified to do this case? I took a quick look at Mr. Pryor's website today. He says he does general misdemeanors and felonies, and he has, many years of experience. And I'm assuming he has at least 10 felony trials, which is kind of their guidelines here. But I don't think that he's ever done a death penalty case. And normally, they like to have the professionals at least co-counsel one before they are a lead chair on the case. The defense team should have at least 1 mitigation specialist and 1 fact investigator. What does that mean? 2 investigators. That's already getting expensive because now you got 2 attorneys, 1 qualified to look into mental health issues, and 2 investigators. At least 1 member qualified by training and experience, screen individuals for the presence of mental or psychological disorders, and any other member needed to provide a zealous and effective representation. Sounds expensive. The attorney that's going to represent somebody in a death penalty case under these ABA guidelines, which have been adopted by Idaho, is obviously have relevant experience and training as it relates to the death penalty. They're saying at least 10 years litigation experience, 10 felony jury trials in which they have been either the lead counsel or co-counsel in which the death penalty might have been imposed. So they're looking at saying, hey, do you have at least 10 jury trials where basically it was a capital case, homicide case? The attorney must have demonstrated necessary proficiency and commitment to exemplify the quality of representation appropriate in a capital case. This is what they're talking about. You have to have skills related to advocacy, fingerprints, ballistics, forensic pathology, DNA evidence, computers. You need to have an experience in that as well. And then the co-counsel has to have at least 5 trials that would qualify for a death penalty case, i.e. a homicide case where the death penalty could have been imposed. Additionally, they're going to say that there needs to be a lead appellate and post-conviction counsel already assembled so that they can look into what they need to do afterwards. Because oftentimes in a death penalty case, you don't do all the appeals. You basically throw a 35C into it here to the lower court so it can all be litigated now by the appellate courts. So a lot of big changes, I think, are coming their way. I think John Pryor needs to take a look at himself and say, hey, am I qualified for this? Am I going to do my client a disfavor if I don't have the resources? Because this is now a full-time job. If it wasn't already a full-time job, it certainly will be. So we'll see what happens. Let me know your thoughts, but I think it's maybe time. New counsel coming in. I would be very surprised if we had a trial in December like we were anticipating. All right, we'll see you next time. Thanks for watching Crime Talk.